very quickly, you'll have the final word without any.
Lawyers talk about legal judgment as though it were something that existed, and assuming it's absolutely culturally and socially conditioned at any given time. This is mostly, I guess, for Saul, but it might be that lawyers and legal scholars who are doing the history to determine meaning of a legal text have to exercise an intellectual virtue that is kind of peculiar to legal practitioners, and that it might even be difficult for people who don't have that virtue to recognize whether it's being done well or not. That's it.
I don't think so.
Let's hear the last comment, and then
so.
You do not, or you do?
Well, I mean, it seems. I mean, I think that's very convenient because that sort of, that's a get out of jail card, right? That you're not held accountable to reasonable historical standards for making a historical claim. I do realize that there are differences. Like, for instance, when I write as an amicus brief and participate in one, I'm engaging with a different voice, and there are different rules. And when you do scholarship, there are different rules as well. But I think that if originalism is going to make claims about truth, they have to be true.
And I agree, notwithstanding anything I might say about the problems of using history. If you're going to do it, at least do it properly.
Do it right.
And say why you and how you're doing it.
Isn't originalism, in a sense, just a nomenclature for one's philosophy? It could have easily been judicial activism. You could have put a different label on it. Conservatism, liberalism. I mean, it's just some judicial judge's interpretation of a document, which, so they gave it the name originalism. It becomes, it just happens to be the nomenclature we're using now. 20 years from now, it may or may not be something that, is in vogue. I mean, the judges have looked at history at all points in time, and they've looked back. That's stare decisis. So aren't you, into a certain degree, emphasizing someone's philosophy, and they have 5 or 6 votes versus the others, and so therefore they're more dominant now than they might have been in the past or in the future?
Well, I think that the theory behind originalism, as the theory behind following precedent, is to try to find a basis for judging which isn't the philosophy of the judge. Now, whether that works or not is much the subject of the panel. But I would like, please join me in thanking us.